Hi, I'm Evan Wright, a partner at JMW Solicitors, and I'm going to tell you why HMRC investigate companies for VAT fraud when the company hasn't committed a VAT fraud, which makes no sense at all, or does it? Let's say you collect VAT and you pay VAT. You do credit checks, you obtain credit references for new suppliers and VAT verification from HMRC. You visit a new supplier to make sure they exist. However, HMRC suddenly pay you a visit and they start talking about missing trader intra-community fraud, or MTIC, and a VAT defaulter. Now, they tell you there has been a serious VAT loss somewhere along your supply chain because of a defaulting trader. Now, they might not initially tell you where the loss has occurred or how much it might be. They ask you questions relating to your supply chain, your accounts, your logistics, your customer KYC checks, and your due diligence. A letter including something along these lines. HMRC is going to investigate this supply chain and might deny your right to claim input tax if it's established that you knew, or you should have known, that you were participating in a supply chain connected with the fraudulent evasion of VAT. You should satisfy yourself you've undertaken sufficient due diligence regarding the integrity of your suppliers, customers, and the underlying supply chains. You need to determine which checks to carry out and whether to enter into transactions in light of those results. Now, they'll often serve a Notice 726, and Section 6 of that refers to the kind of checks you might like to carry out. Furthermore, if you trade in goods referring to as specified or high risk, HMRC will talk to you about how a company and or its directors personally may be held jointly and severally liable for the loss. Now, all of this means that HMRC is trying to recover someone else's VAT default from you. Now, you might say, I didn't know or shouldn't have known, but defending the allegation doesn't simply involve supplying HMRC with copies of the due diligence you undertook. They will look at the company's state of knowledge about each transaction, and a lot of elements make up that knowledge. Now, I become involved at different stages in these cases. Implementation of the proper procedures before HMRC get involved, or helping to prepare for a visit, defending the company's interest during that visit, or preparing responses to HMRC questions after the visit. Maybe advising and defending the company following the issue of a tax loss letter, or preparing a submission for an independent review, or appealing to the tribunal and indeed the higher courts. We might be negotiating penalties and HMRC costs, or appealing those penalties. Now, a responsible company will implement those checks from the outset, and if an internal review reveals concerns about a supplier or supplies, you need to obtain legal advice on whether and to what extent those concerns should be disclosed to HMRC. So far as costs are concerned, every company is concerned about the costs involving lawyers, and here are my thoughts. The cost of a lawyer is small when compared to the cost of an adverse HMRC decision. They don't normally pursue small amounts in cases of this type. A lawyer should really set out anticipated costs in stages and should define what those costs will cover. Now, costs need to be realistic when compared to what they are designed to achieve. Companies shouldn't be afraid of trying to negotiate costs and hourly rates. It may be, for example, possible to use more junior lawyers for some tasks, or to offer fixed fees for stages and cases. But don't forget, a lawyer's costs might be covered by the company's insurance policy, and in fact, the terms of a policy often require the company to notify its insurers of HMRC's involvement, and I'm often asked to advise on the terms of an insurance policy and the timing of notification to an insurer. So in conclusion, if HMRC get in touch, don't just start thinking about the issues at the meeting itself. Preparation is absolutely key. Don't say something to HMRC for the sake of saying something. They increasingly share information between their various departments, and something you think is insignificant for the purposes of one meeting with HMRC can be highly significant to the department across the corridor. A well-drafted submission can discourage or prevent the revenue from proceeding beyond the report arising out of the meeting. It can often avoid tribunal proceedings, and can sometimes assure HMRC that in fact your company has not done anything wrong and doesn't need to be monitored in the medium to long term. So if you're faced with this situation, involve a specialist lawyer. Not that many lawyers come across work of this type, a specialist will happily have a no obligation initial chat. I'm Evan Wright. Thank you for watching, and feel free to get in touch. Thank you.